Everybody. My name is Marty Mascari. I'm with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center. The Aging and Disability Resource Center is a project of the Area Agency on Aging, and they're all under the umbrella of the North Central Texas Council of Governments. We're blessed here today, once again, to have our friends and partners in this series, Haiman+Hogue. We've got Sheila Williamson and Rex Hogue here to talk about blended families, a Brady Bunch nightmare, and its effects on care, estate, guardianship, and probate. And before we get started, if we could advance to slide one, we'll let Sheila talk about the CEUs if we could.
Good morning, everyone. Thank you for bearing with us as we get all set up. To get the CEU credit is very simple. At the end of this presentation, eventually Marty will send out, and I'm going to send him the two forms today that I need back. I need a sign-in sheet and an eval sheet, just like you do any other time you attend a CEU. And I will need those sent to me at sheila@haimanhogue.com. And that way, as soon as you send those to me, then I will send you back your certificate. And it is good for nurses, social workers, assisted living managers, and licensed professional counselors of any kind. So we're so glad you could join us today. And we love doing these presentations as education is our primary core value. One other thing there, I will send you a disclosure statement as well. I do not need that back. That's for your records, explaining to you that, yes, we do this for a living, but this is strictly for education purposes, not to sell anybody anything. We are strictly educating you on all the facts. And also, lastly, there are plenty of time to ask questions at the end of the presentation. So we will be more than happy to, Rex will be, not Sheila, Rex will be happy to answer all the questions that you have. So at the end of the presentation. Thank you.
Very quickly, additionally, we'll have a survey, and our survey is in Google format. It should pop up at the end of the webinar as you log out. We ask if you would complete that as well. That has to do with us reporting back to our funders the objectives that we set forth when we applied for the funding on our part to put these webinars together. So if you please complete that. For those of you that can't get that block up, that form pop up because your company may have pop-up blockers or that type of thing, it will also be in the follow-up email with the forms that I send you from Sheila for the CEUs if you're looking for those. So that being said, Sheila, I'm going to let you introduce Rex.
Okay. For those of you that have not joined us before, Rex Hogue is the founding partner of Haiman+Hogue, our law firm. And he has been practicing for right at 30 years. This is one of his favorite presentations because, number one, it gives a great example of a blended family that everyone is aware of. Although you may think of them as a happy, wonderful family on TV, we're going to show you what actually might be the case. So, because this is what happens when people walk in our door. They're certainly not like what you think. So anyway, he's going to show you practical ways of dealing with that and what'll happen when people you're dealing with, your clients, your patients, whatever, experience some of these. Now you'll be more in tune and aware of what can happen and solutions for the situation. Without any further ado, Rex Hogue.
Okay, we're going to be talking about America's favorite blended family today, the Brady Bunch. I was going to have y'all sing the song, except A, we can't hear you, and B, we don't have enough time for that. But let me tell you that we pulled facts from the show. We pulled facts from the subsequent specials, none of which I've seen, but we did have one of our assistants chase down that information for us. And then some of the facts we made up that are not inconsistent with what we learned. We've added situations that we run into it's unlikely that one family would have all of these things happen, but it's great to have a family that we can work with. So we'll start at the time when Mike is 44, Carol is 43. They've been married 3 years. They have a prenuptial agreement. Mike's kids are Greg, Peter, and Bobby. And then Carol's kids are Marcia, Jan, and Cindy. And then Alice Nelson, their housekeeper, is really part of the family. Mike married right after college. He took a job as an architect with the Phillips firm, and we have moved them to Texas. As you can see, they're in Plano. He became a junior partner 6 years ago. His first wife died 5 years ago, and his grandfather was a judge, Judge Brady, and he owned a 3,000-acre ranch, including oil and gas royalties. His father was a retired petroleum engineer, and the kids know them as Paul and Grammy Brady. He has a lot of oil company stock when he retired, and then he sold most of the ranch. He kept 40 acres. He still lives there. He has some cows, some horses, some chickens. And he put half the proceeds into more minerals and half into more oil company stock. They love having the kids come out. They adore Mike's stepdaughters, who they do all see as daughters. And they keep the boys for a week and they keep the girls for a week each summer, and they just have a ball doing things that you can do on a farm. Mike intends to keep the 40 acres after he inherits it as part of perhaps a family vacation home or Christmas gathering spot. Carol grew up in Massachusetts. She married, she moved to Texas. She divorced 6 years ago. She shares joint custody, but her ex lives out of state. He only sees the girls about once a year. He does have regular communication. She feels that the lack of planning cost her a lot in her divorce. And by the way, we do a fair amount of work with family lawyers, and I can tell you that people going through that's exactly how they feel. The lack of planning costs them a lot of money. They want to keep separate property separate, and there's a lot of reasons for that. She has a brother, Jack, and his wife, Pauline. They live in Austin, not too terribly far away, but interesting that they both wound up in Texas. Carol and Jack were close growing up. Carol's parents were in a bad car accident. Her father was killed. Her mother, Connie, was left severely brain damaged. She did recover physically. That creates a lot of issues because that means that Mike and Carol are part of the sandwich generation. They have minor children to care for, and they have aging parents who need their help. Connie and her husband had no estate planning in place. So they went through probate for Dad in Massachusetts, Colorado, and Texas. They did that because they owned real estate in all of those places. And then they had to do a guardianship for Connie in Massachusetts and then move it to Texas. That is a very complicated process. We're not going to walk you through all that's involved in that, but just take my word for it that that's complicated to do. And sometimes the only real reason for that is because the judge in Massachusetts was reluctant to move her out, but since all the kids lived in Texas or in another state, that's why they did it. Connie now lives in an assisted care facility in Austin. And there's been tension between Jack and Carol on Connie's care. They've gotten along well for years and years, but Connie's incapacity is causing stress between the family. That's not at all uncommon. Jack wants to put her in memory care. Carol thinks Jack and Pauline just don't want to deal with her, and she's kind of annoyed and thinking of moving them here. But then something happened. Connie wanted Jack to call the FBI because she is convinced that there are Russian spies in the facility. She thinks her roommate is one of them, and she even thinks that there is a gentleman who speaks with what she perceives to be a Russian accent to be a Russian spy. And she actually attacked that gentleman with a cane one day. And that has put them in a very difficult situation. The home has told them she either has to leave or she has to go into memory care. And this incident caused Carol to realize Jack is probably doing the best he can. And as a result, they've put her mother in memory care. Now, let's talk about the assets. They have a home that they own jointly. They have checking and savings, household goods. Mike has a 401k. They have 2 cars. They have life insurance on each of them. But the beneficiaries of that life insurance are the spouse and then their own individual kids. We're going to talk about some of the problems that creates, but this is a very common problem in second marriages. Mike also has separate property. He's got an IRA that he is no longer contributing to after the marriage. They did get some good legal advice about not commingling that asset by continuing to contribute to it, though we're going to show you that that's not necessarily as clean and simple as it seems. He's got a 10% interest in the Phillips firm, and there's a rule called the inception of title rule that however something is titled at the moment that title was created, that determines the character of it. That is going to create some stress in this family going forward, as you will see. Carol also has an IRA she's no longer contributing to. They did a prenuptial. The attorneys advised each not to contribute more to the existing IRAs, and they did cover that in the prenuptial agreement. I will tell you, in our experience, that's relatively rare, but we're trying to not make this more complicated than we have already made it. They do keep those IRAs as separate property, and even the growth on them remains separate property according to the prenup. Now, they don't have any formal estate planning. So we're going to start, Mike and Carol pretend like they have come into our office. Here's their scenario. They've given us all this information we've just given you. What if one of them becomes incapacitated? Well, we show them that guardianship becomes the way that that would likely have to be dealt with. Then we talk about what happens if either one of them dies. They find out it's nothing like they imagined. There would be probate for the deceased spouse, and ultimately the second spouse would also have to go through probate. They find that their home, which they each own half of, would be owned, half of it would belong to the surviving spouse and half to the decedent's kids. And that can be a problem if those decedent's kids are still minors, but it's also not a lot of fun to find out that you don't have complete control of your home. You get to share it with kids who hopefully you have a good relationship with. We're going to pretend like they do because the show told us they did, but that may not always be the case. That home, however, would be under a guardianship for the kids for years. Consider that if Mike died first, Bobby is 11 years old. It's going to be at least 7 years before he turns 18, and that guardianship goes away. So that's a long time to have to be dealing with a court. The life insurance, the kids are going to be, again, under guardianship for years. But the good news is when they turn 18, they're going to get that money, which means they'll likely get a nice car, but no college education. Their community property, half to the surviving spouse, half to the decedent's kids. The survivor does not owe those decedent's kids anything past the age of 18. That is huge. In some cases, we're going to pretend like it's not a big issue in this case, but in real life, it's an issue. 1/3 of the separate property would go to the surviving spouse. That can create stress between the kids from a prior marriage and the new spouse to be. But you can also see that one group has an incentive to call everything separate property. The other group has an incentive to call it all community property. Now, if the family doesn't have a plan, we do have a number they can call for help. 1-800-YOU-BLEW-IT. This is going to be a huge mess. The truth is, I don't know that you get anything if you call that number, but that's effectively what you're going to have to do. So let's walk through what an administration would look like. First, there are what we call the administrative dragons. Power of attorney failures, guardianship, probate, medical documents. We're not going to spend a lot of time on those, but we'll talk a little bit about them. And this is a big, nasty green dragon that we say that he walks around on the ground. Then there are taxes, capital gains taxes, gift, estate, and generation skipping taxes. There can also be business entity taxes, entity taxation, tax method, audit risk. We are not going to cover a lot of these taxes today. We are going to talk about some, but not all of them. This is a big, ugly, fire-breathing dragon that everybody knows that IRS stands for I'm really scared, and that dragon is scary looking. The third one is creditor and predator claims, and it involves two things: protecting yourself against lawsuits and protecting what you leave others. Now, my experience is that when we have clients come in and they've been sued, a lot of times I'll hear this statement: that lawsuit came out of nowhere, had no idea, just like that dragon flew out of nowhere. I'm going to tell you, lawsuits do not come out of nowhere. There is always, it is identifiable where they might come from if you know what you're looking for and know how to do it, and that is part of our job. Now we'll start with the big green dragon that walks around on the ground. There are 6 key medical documents. The HIPAA patient authorization, some of you work with these documents, but it authorizes someone to gather medical information. Without that authorization, a person who's not a HIPAA authorized individual cannot get medical information. It's against the law under HIPAA to share it. Then the durable special medical power of attorney that authorizes people you have chosen to make medical decisions. It should be obvious, but sometimes people overlook this. Authorizing somebody to make medical decisions, but not giving them access to the medical information, deprives them of the effective ability to make good medical decisions. We have a document that we prepare for our clients, of personal and healthcare instructions. It's instructional. It's a place where families can say, this is what I would want if, and we've given them 22 pages of what ifs, and they can fill in the blanks. They can choose A, B, C, or D. And it can be from fairly general stuff to very specific stuff. Then comes the directive to physicians, also known as a living will. This is not a do not resuscitate order. People get those confused. This is the authorization to pull the plug if a person is terminally ill. And medical professionals are very reluctant to do that if you don't have a directive in place. The anatomical gift form in Texas covers 2 things. One, it allows you to say whether or not you want to make anatomical gifts, gifts of your whole body, what you would have them used for, who is going to control that. And number 2, it authorizes you to say whether or not you would be willing to undergo an autopsy that's not required by law. So that document is very important, because without it, your family will make those decisions, but most of the time they would really like to do what you would want them to do. Then there's the disposition of remains form that authorizes somebody to make final arrangements. There's a form out there, a medical form service called DocuBank, and our clients get a special deal from DocuBank. They keep these documents on file. They can fax them or email them to any hospital in the world 24/7, 365. We've had clients use the service at 2:30 in the morning on a Saturday. So believe me, DocuBank is a great deal, and we do highly recommend it to our clients. Now, dealing with incapacity, there's the medical side, but now we're going to look at the financial side. First option for how to deal with it is powers of attorney. What a power of attorney is, it's where the principal gives the agent a power of attorney. It's an invitation to third parties to let that agent act on your behalf. Like all invitations, that invitation can be accepted or rejected. And we're going to talk a little bit in a couple of minutes about why third parties would reject it, but it happens way more often than people realize. If the power of attorney fails, then that raises the question, what's plan B? There are two possible plan Bs. One is a guardianship, called conservatorship in some states. We define it as the court-supervised management of assets for somebody who is legally incompetent. The other plan B is a living trust. And we're going to talk about all three of these options and how they might work. But a living trust can replace the power of attorney. It provides the necessary substitute signature, and that's why you go to guardianship, by the way. It avoids guardianship and probate, and it provides instructions for an incapacitated person's care. The guardianship and probate are caused by the exact same problem. The problem is a person is unable to sign necessary documents to manage or transfer their assets. Therefore, we go to court to have a judge authorize a substitute signature. Now, as complicated as guardianship and probate are, the reason for them is simple. A person's unable to sign their name. We have not had any luck getting dead people to sign documents. Apparently they can vote, but they can't sign documents. Guardianship and probate are and frequently the only solution to the problem. My question is, are these the best solutions to the problem? I think when we get finished, you'll see they're not. Guardianship, it takes 12 steps to get in place. Let me go back and say something about powers of attorney. When you take a power of attorney to an institution, that institution is worried about certain things. And I'm just going to use your bank as an example. That's your money. They don't want to give your money to somebody who walks in there with a power of attorney without knowing that that's what you wanted. Well, first of all, you should know that if you die, that power of attorney died with you. If an institution lets somebody use that power of attorney after death, guess what? They're going to have to refund that money to that account. That is not how banks make money. Number two is that they are concerned about whether or not that document is still valid. They have no way of knowing if you redid that document last week. For all they know, John Doe walked in there and he's trying to use an old power of attorney because he can't do anything under the new one. They worry about that kind of stuff because it's happened. Once again, if it turns out that that power of attorney has been replaced, they're going to have to refund the money into the account. Well, those are two big reasons powers of attorney fail. So if you go to guardianship, it's one of those 12-step programs. Nobody wants to be in a 12-step program. Minimum cost is going to be $9,500. I have never seen one done for $9,500. The cheapest one I've ever seen was $17,500. Most of them are more than that. Remember, that was the cheapest one. This is a very expensive way to get a substitute signature. Then once you get it in place, and it can take months to get in place, you're going to spend at least $2,500 minimum to keep it going, but usually more. And it goes on until that person can prove to the court they're no longer incapacitated or they die. And then you get to go to guardianship. It seems like there's a constant stream of surprises. It goes on for as long as the ward is alive. And if I had time to tell you about some guardianship cases, some of them seem funny, but they're not funny when you're in the midst of them. I don't know of a single family that has been through a guardianship that wants to ever go to another one. They are disastrous for otherwise good estate, business, and asset protection planning. Guardianship leads to a lot of time. It takes months to get it in place, a lot of money. You're going to have at least 2 lawyers involved. You're going to have a doctor, and you're going to have a social study, and all those costs come out of the estate. There's a lot of going to court. It usually takes multiple hearings with at least 2 lawyers. There's a loss of control. The family doesn't control this, and the person who's incapacitated doesn't control this. And there's a loss of dignity. Nobody wants to go testify that mom or dad is incompetent in court. It's embarrassing. And it's embarrassing for mom and dad to sit there and watch that happen. And I can remember being in a guardianship hearing one time and watching this poor gentleman in a wheelchair just bawling in the courtroom because of what his family is forced to say about him because he can't manage his own assets. It also creates a major asset protection problem. It opens the door for creditors and predators that is otherwise shut. All they have to do is attach their claim to that probate case or that guardianship case, and there's a 100% chance that case will be heard by the court. Now, here's the issue with guardianship. If a person owns assets in their own name, i.e. it's individually owned, or some form of joint ownership, I'll give you a quick, easy example of a common asset owned by a couple, their home. If the roof needs repairing and one of them is incapacitated and can't sign a contract for the roofing contractor, you may have to go to court for a substitute signature. I have seen guardianship come up for that. Guardianship of the estate is very difficult. Guardianship of the person is easier. Now, what about incapacity if you have a trust? Don't people who have trust still become incapacitated? Yes, they do, but the rules are completely different. Any asset that is in that trust avoids guardianship. That trust actually replaces powers of attorney. The trustee holds legal title to the assets. No institution is going to refuse to deal with a trustee who owns legal title to the assets. They can also have incapacity instructions. We're going to talk about that as this case goes on. The successor trustee manages these assets. That trust is easy to change, manage, and update, but they work best when the assets are fully aligned. So we're going to talk more about how trusts work. But how does this apply to the Bradys? Well, let's go back and watch what they're going through. Connie went through guardianship in Massachusetts. Then it had to be transferred to Texas, and all 3 kids had to approve it. Jack handled most of that, and he got it transferred to a court down in Austin. It was very expensive and time-consuming because they had no planning in place to prevent guardianship. In fact, they didn't even have powers of attorney. The Texas court requires a bond for an estate that costs thousands of dollars a year. Jack is paying that, but he will eventually be repaid. But fortunately, Jack has the money to pay for it. If a child doesn't have that money, you have to look for another guardian. And sometimes the court has no choice but to turn to someone other than the family as the guardian. The court has to prove any changes for taking care of Connie. They require complete financial accounting every year. In short, this is just a nightmare. Nobody wants to go through this. It's expensive, and you find out that your life is not your own. It's controlled by a court and a probate judge and people who might make claims. It's controlled honestly by everybody but the family and the lawyer you hired. Mike and Carol want to avoid guardianship in their own life. They have watched this through Connie, and that is one of their driving reasons for coming in. They do not want what they've seen Connie go through to happen to them. Now, what about death? Well, when a person dies, everything goes through what I call the estate settlement cost funnel. There's some expenses that come out, administrative expenses. And when I look at this funnel and I think of administrative issues, I think of three questions. Which rules apply? How many different rules apply? And where do you put your family in this process? Because if you don't plan, your family will be at the bottom. That is not where most people put their family. Probate expenses are going to come out. If there are predators and creditors, those expenses will come out. Then if there are taxes, those are going to come out. And if you have to file the Form 706, which is the estate tax return, the administrative costs are going to increase significantly, and it's going to take a lot longer. But think of these like a funnel that's not open at the bottom. You turn on all of these spigots, and when you have turned them all off, whatever's left over comes out to the family. Now, how do assets pass? There are only 4 ways that assets pass. So as you're looking at this, you will be reading left to right. The very first thing we look at with every asset is how is it owned and how does it pass? So think of this like you go to the grocery store, they scan every item, and then they put it in one of these bags. So we first look to see, is it owned jointly with right of survivorship? If so, it passes directly to an individual survivor. If it doesn't pass by right of survivorship, we ask, okay, is there a beneficiary designation or a TOD? I refer to this as planning by the box. Why? Because whatever you put in the box dictates the rules. If you put an individual's name in the box, you're now playing by the same rules you are under right of survivorship. Now, these two look very simple. They appear to be very simple. In reality, they're complicated. You can lose complete control over the assets, and it will blow any tax planning you may have done. And you may think, well, I don't have an estate tax problem. That's not the only tax problem out there, folks. Now, if it doesn't pass by beneficiary designation or transfer on death, the next question is it owned by trust? If so, it passes according to the trust terms. If it isn't owned by a trust, the only thing left, it's owned by an individual. It goes through probate, and it's controlled by the person's will or intestate succession. That's the will the state legislature writes for people who either don't write a will or their will is not valid. Now let's go back to the box. Before we do that, if you have a trust, we use what's called a pour-over will to transfer the assets from probate into the trust so that it's ultimately controlled and distributed according to the trust terms. Now let's go back to the box. You can name the trust as the beneficiary in the box, and that means the trust will control it and the trust terms will apply to its distribution. You can also name the probate estate, but the probate estate is the default in case everything else has gone wrong with the box. Now, all 4 of these get assets to the beneficiaries, but they're not equal in the way they do it. So let's take a look at the administrative rules. Once again, we see our same 4 boxes up here, but we have 3 things that are always going to apply. You always have to look at case law. You always have to look at banking regulations, and you always have to look at the Internal Revenue Code and the Treasury regs. Now, right of survivorship and beneficiary designations have one common set of rules. In each state where you have owners, survivors, beneficiaries, or where assets are located, you're going to have to deal with certain laws. Please note, the Internal Revenue Code has special bad tax rules that apply to these 2 methods of passing assets. Then you have to deal with the Estates Code or the Probate Code the property code, the insurance code, the family code, whatever issues come up, we're going to talk about how those might come into play. If it's owned by a trust, you deal with one state's trust code, the trust itself and the state's trust code. You don't have to look at a whole bunch of other laws, and you don't have to look at them in other states. If an asset is owned by an individual, then you're going to have to go through probate in each state where they own a real property interest. Now, you may think that's very straightforward. Real estate's obvious. But in Texas, mineral interests are real property interests. In some states, they're personal property interests. So if you have mineral interests in multiple states, you may have multiple sets of rules, and some of it may be personal, some of it may be real property, depending on the states. Now, if you just look at this chart, it should be obvious, but the simplest way to administer an estate is going through the trust. You only deal with one law. You don't have to go to court. You don't have multiple laws in multiple states. So we're going to take a look at how that comes into play. We just have a warning here: don't overuse right of survivorship and don't overuse beneficiary designations. In fact, they should rarely be used. Probate technically means to prove up the will. However, I think the layman's definition is easier to understand. The layman's definition is the court-supervised transfer of assets for someone who has died, and it really is a court-supervised process. People want to know, when it comes to probate, they ask us two questions. How much does it cost, and how long does probate take? Well, let me tell you, if somebody is being honest with you, they cannot give you a straight answer to either one of those questions. I'm going to show you why, but they're the wrong questions to ask. If you knew to ask, this is what you would ask. Who gets paid first, and who controls the process? Now, I'm about to show you what our Texas Estates Code says about the order of payments in probate. Number one, funeral and last illness of $15,000 each if the court approves. When you see a phrase in the code somewhere or in the law that says if the court approves, you should understand the way courts approve things, lawyers go to court and argue it. Getting the court to approve it is not cheap. Secondly, family allowance for up to 1 year if you have qualifying family members. That's going to be surviving spouse, minor children, and incapacitated adult children. Then comes the cost of administration, attorneys, court costs, executor fees. This, by the way, is our favorite part of the process. You might have guessed because we get paid. Well, sort of, but I'm kidding. The truth is we don't have to take a case until we've been paid. So we've only let the funeral directors think they're ahead of us. But you've got other expenses that come out then. Then comes secured claims and tax liens, unpaid child support and interest. Then taxes, penalties, and interest. I hear you all cheering. Yes, that's the IRS. Look at all the people in Texas ahead of the IRS when you go to probate. It's a small thing to cheer about, but it's something. Then comes the cost of confinement. If a person was in jail or prison, the state can go after recouping those costs. Then comes repayment of medical assistance. Then comes other claims. Let me give you one, and this is going to apply to Connie's case. She has rental property. Well, one of the renters got real slick here, and he said, hey, I'm supposed to pay Connie, but she's died. So until her estate is set up and I can pay the estate, I'm not going to pay rent. And there's nothing anyone can do about that. It's very frustrating. We have been in that situation a few times with clients, and the aggravation for the kids, they've got to pay the taxes, they've got to pay insurance, they've got to pay repairs, and they don't get money until they've gotten far enough into the probate process to be able to have estates made the estate be a check made to the estate so they can start dealing with it. But did you happen to notice who isn't on the list? Take a quick look. Well, I'll tell you, it's the family. If you go through probate, your family is last on the list. Is that really where you put them? Now, it's nice to know the order of payments, but who controls this process? Well, I will tell you, it's everybody but the attorneys, the court, and the executor. It's all these other people who make some kind of claim. And I've had clients show up and say, oh, mom didn't have any debts, or dad didn't have any debts. But go file a probate with an inventory that the whole world can see, and you might suddenly find there's people claiming mom or dad owed them money. It happens. Sometimes, most of the time, I'm going to say those are legitimate. Sometimes they're not. But kids don't always know. Families don't always know. But it's people who make claims who control the process. We don't know how many claims will be made. We don't know how long it will take to resolve those claims. And we don't know how much it will cost to resolve those claims. So anybody who tells you we know the cost of probate and how long it will take, they will lie to you about other things too. Probate, my definition of it, is a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. My experience with clients, those people are not on the list of who they want to protect. Now, application to the Bradys. Upon the death of either, the home would be jointly owned. It's going to require probate and a guardianship, and the spouse is going to have limited options. Mike's 401k is going to go to Carol. She's going to roll it over. Chances are good his kids will never see it. That isn't really what Mike wants to see happen. Life insurance, kids as beneficiary, is going to require a guardianship, and then they get their share at 18. We all know the average 18-year-old doesn't have their brain completely installed yet. That's not going to come till later, and they're going to go do something stupid. Guardianship, if a survivor is incapacitated, and then a probate upon their death. An example of this is Connie and her husband. Her husband was killed in a car accident. Connie was incapacitated. Had to do probates for the husband and a guardianship for Connie. So one of the reasons we brought that up is we've had that come up in cases, and we wanted people to see, hey, here's a real live example of how that happens. Now, what is a trust? It's a contract that involves three parties. The trust maker goes by other names. That's the person who creates the trust. They make up the rules of the game. The trustee is the boss. They manage the trust assets. They manage the assets according to the rules the trust maker set up for the benefit of the third party, the beneficiary. Now, in most cases, one person is the trust maker, the trustee, and the beneficiary. But if they become incapacitated, a new trustee steps in, and they have to still follow the rules. We're going to show you how that applies here. And I just said it, in a typical revocable living trust, the trust maker serves in all three roles. The trustee holds assets for the trust. That's often stated as though the trust owns the assets. There are some technical legal differences that are beyond the scope today and not real relevant to this, but if you read that somewhere, I'm telling you, that may be technically right, but for our purposes, think of it like it's owned by the trust. Assets in the trust avoid guardianship and probate. So while alive, the trust avoids guardianship. It can provide instructions for care in case of incapacity. Now, one of the things that Mike and Carol have learned is that if Connie had had a trust and had these kind of instructions, it would have been easier for Jack to get her into a facility and get her in. First of all, he wouldn't have had a judge approving the facility. She could have said, these are the facility features that I want. We put those in trusts all the time. Not everybody does, but we do in ours. It can also give a person a chance to see how the successor trustee does managing the assets. Sometimes that's important. It's not always possible, though. If Connie were concerned about the way her kids managed money, she didn't have any planning in place to keep them from managing it. Trusts are easy to manage, easy to change, easy to update, but again, they work best when you get the assets aligned with the trust while you are alive. And what that means is getting your bank account owned by the trust, getting your brokerage account owned by the trust, getting your home transferred into the trust. Those things are not very difficult to do, but they're important to make the trust work well. After death, assets owned by the trust avoid probate. It can provide distribution instructions for all assets. Now, you may think, what's the big deal with that? I'll tell you what the big deal is. Where you've got minor children or children who you don't think are of age to manage money, you have instructions saying to the trustee, this is how I want the money used. I don't want my kids to go buy a Lamborghini just because I happen to have left them enough to do it. I want that money used for their college education. I want them to, buy books, pay room and board, that kind of stuff. That'll do the kid way more good than that Lamborghini for the rest of their life. They're going to have faster access to assets. I'm amused by people who think, oh, right of survivorship, you're going to get that right afterwards. Not always. Sometimes you have to show a death certificate. We have a case where it took over 8 months to get a death certificate. 8 months. Family, stone cold, can't do anything. But if it's in the trust, another trustee can step over and take that over in a matter of days. It's faster and easier to administer. There's fewer complex rules than right of survivorship, beneficiary designations, and probate, and it's only one state. It provides more certainty of results than other distribution rules. We're going to give you an example of that. Now, what a trust could do for them, it could pass all assets by trust terms that's more favorable while they're alive and upon their death. It avoids probate in Texas. It protects the spouse from existing creditors, future lawsuit creditors, and divorce if they get remarried. By the way, let me go back to it avoids probate in Texas. You need to think about this. Both Mike and Carol, assuming they outlive their parents, are going to inherit. They are both going to inherit assets, or at least it's possible that they would inherit assets outside of Texas. So it's important that they have a plan that will avoid probate even in other states. It's going to avoid guardianship for the children. It's going to provide for the kids' college education with rules that keep the kids from becoming a professional student. It's going to protect the kids from existing creditors, future lawsuits, and divorce in the future. Our family money and money protection plan provides medical documents for both, a plan for the possible incapacity of either. It's going to provide instructions, avoid probate, guardianship for the kids upon death. It's going to have one vehicle to transfer all the assets. You're not going to have things going multiple ways that frequently conflict with each other. The kids are going to get a college education, at least up to a bachelor's degree, or at least the money is there to encourage it. Now, they also want to do some charitable stuff. They want to give a contribution of $10,000 to Big Church in Frisco, where they go to church. And Carol wants to give $10,000 to Mothers Against Drunk Driving. Why? This has become a issue very dear to her. Her mother and dad were in an accident with a drunk driver. I forgot to mention that. But she wants to contribute to MAD because of that. Their community property. Right now, they want to give 1/7 to each child and 1/7 to Alice because she's been such a part of the family. The survivor gets the house in exchange for other assets, so they won't split it between the kids. The B share is going to protect the survivor and the decedent's children in case the survivor gets remarried. So if Mike dies and Carol gets remarried, do you think the boys are a little worried about what's going to happen to their share? Trust me, if they haven't thought about it yet, they eventually will be. It's going to provide enough to get the kids started in life. That's important. And it's going to go to those kids in such a way that it's both protected and they'll get control of it later in life when it will help them more. The separate property, there's going to be some benefits going to the surviving spouse, and there's going to be some that goes into trust for the decedent's kids. So two different ways that they're going to treat separate property. This is not uncommon. We're going to talk about the assets that they're going to have bypass the spouse, but in second marriages, it's common to have some things that'll take care of the spouse and some things go on. Ultimately, all the separate property will go to the decedent's kids, and all the community property will be divided by 7. Now, we just showed you their plan as though we did it today, but we're now going to move Mike and Carol back 21 years. And we're going to look at what's happened in the 21 years since they did that plan. And you're going to see a lot of changes. And one of the reasons for doing this is so that you can see a plan isn't static. You do a plan, but things are going to change over time. So this is what happens when life goes on. We talked about, we started this plan when they were about 3 years into their 5-year run as the Brady Bunch. Now Mike and Carol are 65 and 64. The kids are 38, 36, 35, 33, 32, and 30. They've all gone to college, graduated, they have lives. But we're going to start chronologically since the first plan and tell you what's happened. Carol's mom died 19 years ago, 2 years after we did the plan we talked about a few minutes ago. It took 3 years to get everything through probate. Probate was more expensive than they expected. They had to go through probate in multiple states. Carol inherited a condo in California, 2 rental properties in Texas, and money. She had a brother who inherited comparable assets and a sister who lives up in Washington who also inherited comparable assets. Paul Brady passed 7 years ago from cancer. Cindy was in college when that happened. Paul and Grammy Brady had good planning, and it made estate settlement much simpler. Mike helped his mom, Grammy, sell the ranch. Now, very common, Mike had planned to keep the 40 acres, use it in his lifetime, thought, man, what a great place, a family gathering place. But reality came into play when his mom, he realized she could not take care of it, and she needed to be in an independent living facility and closer to them. So they moved Grammy to an assisted living facility close to them. And good planning made her incapacity simple. They had instructions in their trust that said, this is the kind of facility features we want. It took Mike only 20 minutes to find 2 places within 10 minutes of where they live that met all of Grammy's expectations. That's great planning on the part of Paul and Grammy Brady. Then Grammy died 5 years ago. So they went through the administration. Now, Paul had asked Mike to pass any leftover ranch proceeds by 9 on Mike's death. The boys were to get 2 nights each, and the girls were to get 1 night each. So Pa and Grammy Brady decided to give to the Brady girls something because they loved them and, considered them part of the family. But I want to ask you a question. How do you think this is going to go over with the boys? That the ranch that's been in the family for generations was sold, and now their stepsisters are getting 1/3 of it, and they're only getting 2/3. Now, that could create a lot of resentment. It helps a lot that it's been written out. The oil and gas revenue went straight to the boys on Mike's death. Now, that was separate property. That makes sense. But my question is, do you think the girls might resent that? Especially when oil prices are high like they are right now, and that revenue, those royalties, may be higher now than they've been in many years. That's happening to people who have mineral interests today. That oil company stock ultimately goes to the boys, but Carol can benefit while she's alive. So it's going to be used to take care of her. Then Sam retired, and he and Alice moved away 5 years ago. And they loved Alice for years and years. They still love Alice, but she's no longer part of their life. So they're no longer going to plan for Alice. Then 16 years ago, Carol, after going through all the stuff with her mom, she took some of her inherited money and some community money and bought a real estate business. Now, they didn't purchase it until they had access to the money, but we're going to raise this issue again. Just make a note, that's half community that went into it and half were separate. Mike is retiring now as a senior partner, and he's been diagnosed recently with stage 3 multiple myeloma. They are telling him that while he's likely to live for a while, he's likely to be wheelchair bound in another 1 to 2 years. He has a 4 to 6 year life expectancy. Now, ultimately, with multiple myeloma, some of you know this, that's not what kills you. It's usually something else. It just weakens you so that you can't resist something else. So Carol put her own company up for sale so she and Mike can travel and do things while he is still able to. But they're actively preparing for Mike's incapacity. They sold their home and they bought a single-story home. They downsized to make it easier to take care of. Now let's talk about the kids. Greg is married to Nora. She's a nurse. They have a son, Kevin. Mike and Carol adore Nora. They think she's a wonderful wife for Greg, but they are concerned if something happened to her that Greg might fall for a gold digger. Nora's a very pretty lady, and Greg was always girl crazy, if you remember, and they just don't know what he might go for under the stress of Nora's death. He's an obstetrician. He's done very well financially. They don't need Nora's income. So Nora quit her nursing career to go into a catering business with other family members. That's going to create some issues. That came from one of the specials. That's not part we made up. Greg owns a beach house. Greg has always seen himself as the big brother to take care of everything. So he's let everybody else use the beach house for a week in the summer, no rent. Just leave it like you found it. And it's been wonderful for Greg to have that in the family. And he sees his sisters as his sisters. He feels close to all of them. And he looks out for all of them. Peter served as an officer in the Air Force. That changed his life and gave him direction after his service. He got a business degree. He is good with money. He has had one broken engagement, so he is still single. Greg has introduced him to several women, but so far, none of those have worked out. So Bobby is, Mike and Carol would have preferred at this stage that he be married and maybe even have grandkids for them, but that hasn't happened. That creates some unique planning issues. Now, Peter and Bobby have always been close, and he's gone into business with Bobby. And he's happy to help his injured brother. We're going to talk about that in a minute. But he sees, he looks up to his big brother, and he looks to help out his little brother. He remembers Greg paying for him to fly home one Christmas, fly home for Christmas while he was on leave one year. When it was a struggle for him to do it, Greg stepped up and said, "Hey, I'll pay for you to fly home." So Peter is very close to his brothers, but he sees his sisters as stepsisters. He's not as close to them, and that's going to make a difference in the kind of, maybe not the planning, but it's going to make a difference in the way these kids see each other. He is closest to Jan of all of the girls, and she was the one closest to his age. Bobby became a race car driver, but a crash left him significantly disabled. For a while, he was paralyzed, but he's gone through rehab. He is improving, and he went back to school and got his business degree at 28. Mike and Carol paid for that. That's an important planning consideration, because maybe they want to consider that they have maybe paid more for Bobby than others. I don't know if that will make a difference. We're going to pretend like it didn't, but it's at least something for them to consider. He is good with money, but because he is wheelchair bound, he's not able to make as much because of those limitations. He's married to Tracy. Mike and Carol love Tracy. Peter likes Tracy, but he doesn't want to be in business with her if something happens to Bobby. So Peter and Bobby have a business, and then I'm going to talk about what about the family business that is another business. He sees the girls as stepsisters. He's closest to Cindy and then to Jan. Bobby and Peter both feel somewhat estranged for Marcia. Tracy went into business with Nora, Marcia, and Wally. We're going to talk about Marcia and Wally next, but just giving you the background by individual. Marcia, now 36, she's graduated from college. She became a fashion designer. She married Wally. He's a fun, loving, likable guy, toy salesman. Unfortunately, he's often out of work. She's also had an alcohol problem, but she hasn't had a drink in 3 years, so she seems to have recovered from it. She now stays home with their 2 kids, but she really wants to go do something. She's still popular and outgoing, Miss Personality. Everybody likes Marcia. Everybody likes Wally. They love having them come to parties. However, she is not as good a decision maker. She's not a good money manager, and neither is Wally, and as a result, they've struggled financially. Mike and Carol have helped them out from time to time. Mike and Carol have decided they're going to treat those as gifts. They're not going to try to make that up later on, but there's another issue that we're going to deal with. She feels very close to Greg. She really likes Nora, but she does feel estranged from Bobby and Peter. And she sees them as not just stepbrothers, but her little annoying stepbrothers. And it's incomprehensible to her why they're doing so much better than she and Wally. Mike and Carol she does like Bobby's wife, Tracy, and was willing to go into business with her. Jan is 33. She married a guy named Philip Covington. He was one of her science profs in college. She became an architect at the Phillips firm. Turns out they can't conceive. They've adopted a Korean girl named Patty. Mike and Carol see Patty as their granddaughter. Now, sometimes that doesn't happen. They don't consider adopted ones, especially if it was a child from prior to the marriage, but that's not the issue here. She's still jealous of Marcia's popularity and personality, but she got the brains and the good decision-making skills. She's past Marcia in a lot of ways. She's a good decision maker, she's good with money, and so is her husband. So they've done well. She might be up for junior partner with Mike retiring. Now, I want you to think about this. Jan might be very interested in somehow acquiring Mike's interest in the firm, but it's Mike's separate property. Just be aware that might be something they want to do. She's closest to Peter and Bobby. She looks up to Greg, and she actually sees all the boys as her brothers. So it's interesting that every kid sees the rest of the family differently. Mike and Carol like Philip. He's good for Jan, and they think they're set, they're on their way, things are going well for them. Cindy's a college grad. She's 30. She majored in mass comm. She's now a radio DJ. She married her boss, Kim Michaelman, a Jewish widower who is more than 15 years her senior. They married 2 years ago, about a year after his wife died. There was no affair. They met and got married fairly quickly. Now, she has 2 stepchildren. This is a challenge for Mike and Carol to deal with. She's 10 years older than the oldest one. Now, think about that. Greg is about 7 or 8 years older than Cindy. That's the age of an older sibling, not a parent. The children were 18 and 16 when they married, so she didn't really raise them. And they definitely don't see her really as mom. They see her as stepmom. That kid is good with money. He's very conservative. He's good for Cindy. Mike and Carol like him. He kind of overshadows her. But the children here are just a challenge. Do Mike and Carol want what they leave for Cindy to go to them, or do they want it to go to their other siblings? They see rifts between the sets of kids and the girls. Now, firm insurance should cover Mike's medical. They're concerned the girls might not understand Mike's business being a separate property, since they didn't know he was a partner before he and Carol married. It's probably not something you talk about with little kids. My kids, they knew I'm a lawyer when they were real little, but they really didn't know what that meant or my position or anything like that. They're hoping for the best for the business with the 2 daughters-in-law and Marcia and Wally, but there's another issue that's arisen. They're concerned that a failure of that business could create a huge rift in the family. Greg loaned Peter and Bobby interest-free money for their business. They paid it back. Greg told them privately that he is concerned that Marcia and Wally won't pay him back. He loaned them money for their share of the business, and he invested with Nora. Tracy, she and Bobby invested on their own, but Greg has ultimately told his parents, while he's concerned he might never be paid back, she's still his sister. He doesn't want it to create a rift in the family. But obviously there's some concerns there. The boys might not understand why Pa and Grammy wanted to give any proceeds to the ranch that was their great-grandfather's ranch to the girls. That may drive a wedge between them. Cindy and Marcia have mentioned they think Carol's real estate business should be her separate property because Mike's business is his separate property. But remember, half of the proceeds that went into it came from community property funds. And again, that's not necessarily something that they would tell the kids. The girl's father has been in the picture now for 6 years. He was somewhat estranged, saw him once a year for years, but now, for the last 6 years, he's been in the picture, goes on vacation with them, and his wife has kids from prior to the marriage, and both sets of families go on joint vacations. So they actually have another family now. He has 2 stepchildren. The girls know, and they seem to like them. They're likely to inherit from him, but the amount is unknown. Now, Mike and Carol may consider that. We're going to pretend here like they didn't, but sometimes in second marriages, clients do consider that. Marcia appreciates Greg. She thinks Jan believes they are still in competition, and she sees Cindy as the baby. Marcia just doesn't truly have a lot of respect for her younger sisters, is the way they see it. She thinks Peter and Bobby benefited from something other than hard work and good choices, namely luck and just, something other than them working hard. She doesn't understand why Wally hadn't been successful. He's a lot of fun, even if he's a little quirky, and she might feel like the family failure, though she probably wouldn't admit it, but she might resent that all the others are doing better. Now, their joint assets, home, brokerage account, checking and savings, household goods, the 401k and IRA, where Mike has made Carol the primary beneficiary. And then the 401k that Carol has, where she's made Mike the primary. They have 2 cars, life insurance on both, and now the trust owns and is the beneficiary of that life insurance. The pre-marriage IRAs, the boys are the primary on Mike's architectural 10%. Probably they're going to work out a deal where Jan can buy that out. We didn't map that out because we didn't have enough time, but that's certainly something we thought of. The inherited assets, the oil company stock from Paul and Grammy, the oil and gas royalty, Paul Brady's gun collection. Carol's assets, she's got the premarital IRA. She inherited 2 residential rentals, and Mike did a lot of free work on them. So Mike has said, hey, I don't want anything back for that. That's yours. But the boys may not feel that same way. She inherited a brokerage account and a Colorado condo, and her mother had a China doll collection. Now, Cindy, who's the family doll lover, has that collection. Cindy would tell Jan and Marcia, Carol told Jan and Marcia that Cindy was holding that since they didn't have room for it after downsizing. But Cindy told Jan and Marcia that Carol gave it to her. This comes up more than you might realize in families, and it can create real rifts between the kids. Especially if Carol doesn't put anything in writing and just lets them guess what really happened. Medical decisions, they've got each other first, then Greg because he's a doctor, Nora because of her nursing background, then Jan, and then Peter. They have not selected Bobby because of his incapacity. They didn't select Marcia because she's just not a good decision maker. And they didn't select Cindy because they feel like she's got too many issues within her own family and her stepdaughters. Their charities, they want to contribute now $50,000 to MAD on Carol's death and $50,000 to cancer research by Mike since his father died of cancer. And they want to now contribute $100,000 to Big Church in Frisco. They've now been there a really long time. So this is what the plan looks like when you put it in a chart. They want to take care of each other while they're alive. They're going to do an AB plan. The survivor benefits from both. The B share goes to the first decedent's beneficiaries. That prevents disinheriting any children, reduces friction if they do get remarried. It's also going to reduce friction between them and between the surviving spouse and the decedent's kids. The B share is not part of the survivor's taxable estate, and the growth from that is going to be removed from the survivor's estate. It's going to avoid capital gains tax on both deaths. When one dies, the separate assets are going to go for multiple purposes. So we're going to show you how we map that out. The A side is the survivor's share. The B share is the decedent's share. The survivor's the beneficiary of both, and it's going to pass everything using both of their exemptions, which right now are very high. They're scheduled to be cut in half January the 1st of 2026. But right now, this year, it's $12.06 million per person. The community property, it's the simplest part to plan. They want it equally divided between the 6 children. Mike's separate property, well, there's 2 shares. So what we call separate one, Carol receives the income while she's alive. She gets principal for her health and maintenance. Benefits end if she remarries, though. After she passes, 1/9 of the oil stock goes to each girl in trust. 2/9 goes to each boy in trust. Everything else goes to the boys in trust. Her separate property too, when Mike dies, it all goes immediately to the boys in trust and bypasses Carol. Carol's separate property one, Mike receives income while he's alive, principal for health and maintenance, benefits end if he remarries. And after he dies, everything goes to the girls immediately in trust. Carol's separate property too goes into trust immediately for the girls upon her death. If she predeceases Mike, it bypasses him. Now, one of the reasons that we did this and showed this in a blended family is we can show the various ways that people do this in second marriages. Now, predator dragons, we're not going to spend a lot of time on this, but basically we're trying to protect assets from unnecessary loss. So the biggest risk to your estate plan is your child's spouse's divorce lawyer. They want to make sure that if their kids go through a divorce, what they leave their kids isn't taken in that divorce. They also want to make sure that if a beneficiary has debts, like extraordinary bills, especially medical bills, like one of the kids gets hurt in an accident like Bobby did, they don't want that to wipe him out. They don't want it to cost him his inheritance. They're also worried about predator threats. The kids, well, except for Cindy, one way or the other, all the families are in business for themselves. Does a beneficiary have a high lawsuit risk job? Greg certainly does. Catering business, I'm not so sure about that. I guess food poisoning can always be a thing, but generally that's safe. We haven't defined the nature of Peter and Bobby's business, but if you're a business owner, you have a lawsuit risk, not necessarily because your business is high risk, but if you're ever involved in a car accident, the person who told you that they were okay, oh, you're a business owner, man, my neck and back, I mean, you seem like a person with assets, you become a target. You also have to consider what state does a beneficiary live in. The laws are different from state to state. How would the loss of those inherited assets affect your beneficiaries? Well, in Marcia's case, it would be everything that she's really likely to have. She and Wally don't truly have a lot. Everybody else could survive the loss of that a little bit better, but they don't want them to go through that. When the beneficiary receives it, there's 3 ways it can pass. It could be outright. It provides no protection for the beneficiaries. It could be in a convenience trust. It also provides no protection. Or it could go in a heritage trust where it's protected from creditors and lawsuit predators, bad marriages, first death in marriage, loss of government benefits, and even from the IRS. Now, which way makes the most sense? Well, we're going to share this story with you. Carrie was a young lady who inherited $3 million. She was involved in an accident where 3 people were killed. What happened is she was hit at an intersection and it caused her to veer off and she T-boned a van loaded of daycare kids. The driver who hit her was found 90% liable, but she was found 10% liable. There was a $9.8 million judgment. Carrie lived in Colorado. Under Colorado law, if you're 10% liable, you can pay 100% of the claim. Her entire inheritance was wiped out. Under Texas law, you would have to be at least 50% liable. If you live in California and you heard about the accident, you could be liable. I'm kidding about that. Though my California colleagues tell me you're not that far off. Compare that to the story of Ted. Ted got a little bit too much elbow exercise one night. He failed to negotiate the bridge over the Chappaquiddick River, and Mary Jo Kopechne died. That happened in 1969. Ted Kennedy, 100% at fault. He was drunk. The Kopechne family wanted to go after Ted Kennedy, but they discovered his parents had left the assets in a heritage trust. They could not touch it. All they could collect from him was the life insurance. Now, doesn't it seem odd that Carrie is 10% liable, Ted's 100% liable, Carrie lost everything, Ted loses nothing. That's the power of good planning. Let me show you two other ways that Ted Kennedy's trust came into play. In 1982, he went through a divorce with Joan. It shouldn't have been a surprise to her that none of that Kennedy money would go to her, but it may have come as a shock to find out that none of the Kennedy money even counted against him in the divorce settlement. It turned out that Ted Kennedy had to be treated like he was penniless, except for what he and Joan had. That's huge protection for Ted Kennedy. Another way it came up is he remarried a lady named Vicki, and when he died, Vicki discovered, like Jackie Kennedy and Ethel Kennedy, because her name didn't start out as Kennedy when they were born, they were not beneficiaries of that heritage trust. It stayed in the family bloodline. Now for the annoying part, the Kennedys will never have to go through paying estate tax on all that money. And if any beneficiary ever qualified for a governmental assistance program, they'll still be eligible for that program, and that money can't be counted against them. Now, what kind of protection do you think Mike and Carol wanted for their kids? If you said, Ted Kennedy, give yourself a cookie, you're right. So this is an example of how we plan. We analyze the situation, financial, determine goals and objectives, specific planning tools. We look at the family situation. We look at everything that comes into play. And you can see that Mike and Carol, you've seen the two plans, they're actually quite a bit different, but their situation's very different. So don't think we did our estate plan 21 years ago, it's still good. No, probably not. You have to consider what you're trying to protect, who you're trying to protect it from, and what tools might work. Every case is different. But without planning, your money is just sitting out there, and dragons are going to come. It's only a matter of time before one of them comes and snatches that bag of money right out of your hands. Our job is to take where you are, build a castle that you can live in. Dragons will still come, but they can't get into the dragon, and you even have a knight to fight off the dragons. At that point, I apologize for going a little long, but I'm happy to answer any questions at this point.
I haven't seen any. If you all have any questions, if you could put those in the chat or the Q&A. But in the meantime, if we could go to the next slide, I'm going to have Sheila review the, I'm sorry. I'm going to have Sheila review the CEUs, please.
Certainly, because that seems to be part of the questions, yes. Okay, yes. Again, Marty will send you the documents that you need to send back to me. It is the eval and the sign-in sheet. Okay, so when you get those, if you will fill those out, send those back to me, then I will be happy to send you your certificate. Okay, are there slides available? Yes, Marty did put a link in there, but he will also send you a copy of them. So,
and I will put that in just real quick again. I've put it in a couple of times, but I realized that if you join after I put them in, your chat doesn't show what was in there before you joined. So I'm going to put it in there again. And then, yes, that will go out in the email, the follow-up email that you will have either later today or tomorrow. And then, again, when you fill out those documents, those go to Sheila. But we also have a Google survey that we need you to fill out if you would. This is part of our collecting information to show our funders how we've done in regards to our objectives that we set forth when we applied for the funding to do these webinars. So please, if you could fill out that. If it doesn't pop up when you close out of Zoom, that link will also be in the follow-up email, as well as links to flyers for several upcoming webinars that you might be interested in. So anybody, no questions? I still don't see anything.
All right, here's one.
Got it.
With the Heritage Trust in Texas, generally, any significant reason not to use Heritage?
That's a great question. In my opinion, I think everybody would benefit. It does cost more money to set it up. And there are situations where we tell people, for example, a married couple without kids, they're going to give everything to nieces and nephews. They might not want to spend the extra money. But I tell people, don't give up too quickly. We've actually had the parents of those kids say, we'll pay the extra to provide that. It's rare, but normally you're going to do the Heritage Trust because the people you care about, you want to protect them. And no real reason not to use it.
Except, Rex, what if the person doesn't, they want to give their money to charity? Would they still need to do that? I don't know.
Okay, that's another great example when you would not use the Heritage Trust. The charities don't need it. It's protected when it goes to them.
Okay.
Well, I just want to make it clear, if anybody's leaving me any money, I'll pay for that. How do I notify?
Me too.
How do I notify all my relatives, extended family of that?
Well, the reason I said that about charity, we did, Rex and I did, he did a talk the other day, and there are people in there, people in there that did not have, they wanted to leave their money to charity and ask if we did that. Yes, and you'd be surprised, that's becoming more common now.
Yeah.
So, and he told them, yes, that obviously we do that. And yes.
No.
So, and you'd be surprised. I mean, if they don't have children and they don't, for whatever reason, don't have any family they want to leave it to. And so we have had, Rex will tell you, we have one family that has left theirs to 17 charities. So, I mean, it depends on, depends on the person.
That's very, very nice. That's great stuff. Yeah. Well, Rex and Sheila, thank you so very much. Once again, just very, very impressive information. Thank you all for joining us today. We certainly appreciate you all being here. And the follow-up email, look for that. That should go out tomorrow. If we could flip to the, no, I don't know. We don't have a next slide because I forgot. We got to set up for August.
No.
I got to get with you to set up the topic for August. We will be here in August, but we haven't set up the topic yet. That will go out probably not in the first follow-up, but in the second follow-up email, you'll have the flyer link to our August presentation for this partnership. But thank you, Rex. Thank you, Sheila. Thank you all so much. Thanks, everybody. Thanks, everybody, for bearing with us today. We certainly appreciate it. And you all have a wonderful day.